that these things become a reality. You understand? The Public Order Act is true, yes. It says that IEC, gives out permits. But we all know that even if we give out permit, you need what? You need permission in order for you to use loudspeakers and things like that. So that's why we said there is something that we have to work on. We can give out permits, but you don't just give. You know how your political rallies look like. You know, you have your drummings, you have your loudly, you have your music and things like that. If we give you permit, I will also give you permit to use those things. So that is why we are telling you that there is some, we have to look at that. You know, who is doing what? Whether we still dealing with the IGP who has the powers to tell you, you can use your loud healers and your music and things like that. We can give you permit to go around, but we don't have the permit to tell you, apart from elections, we don't have the permit to tell you, use what? Use DJs here, use your drummers and things like that. You understand? That's what we are trying to see. You know, like, so we have to always put, it's just like the referendum. Section 226, you know, how a referendum should like 50%, you know, and 75. So you understand. But in the bill here is saying simple majority. So these are some of the things that we say we have to write before the bill passes, so that at least at the end of the day, there will not be what? The bill will not say one thing and then we say no. The supremacy of the Constitution, Section 4, so of the Constitution, so what do we do? So that's what we say. That's why we brought out all these issues so that we can see how to put them in line with the Constitution so that we will not have problems tomorrow. The Act will not say this, and it's just like, I just give an example. In the current Constitution, if you want election petition, it's 10 days. But if you go to the Act, it's telling you 30 days. So there is a inconsistency. So these are some of the things that we've brought out so that we can work it out, so that, from the onset, when we are passing this bill, we see that all the laws, you know, are almost, you know, at par. Yeah, they tally. So sometimes you have to read the connectedness of the law. Even like if you look at some of these things, like if you look at the bill, we'll in fact give you some of the objection form in the bill is not the correct one. So we've corrected all these things, the claimant form, even the code of campaign ethics. So we've copied everything, we've made everything. The constituencies, on the schedule and the constituencies, we've corrected everything and we'll give you all this. That's why I said we will go back and then we'll tell you, like if it's an application on the election bill, maybe we'll ask you the action we want you to take, delete. And then we'll make a comment and tell you, you delete because of so and so and so. You understand? So we'll do that. This was just a summary of telling you the salient points. I hope I'm of help.
All right, next on my list we have...
Section 39, subsection 1 not still be a challenge. Yes, of the Constitution.
No, why I talked about Section 3. Section 3 and Section 16. You see, if you look at it, then what our work will be full time. Yeah. Because it's talking of if you begin even whereas because we begin in the registration on 29th May. So if you begin the registration on 29th May and this bill comes into play and it tells you you have to begin everything again, what you have done is null and void, so it's useless. So that is what I mean. I'm not talking about the Section 39. Section 39 is another. I'm telling you, if these ones are like this, the Section 16 that I'm talking of, if it's removed, if it's deleted, you understand that 6 months you cannot do registration, because if I told you there's a clause in the current Elections Act, which was amended in 2015, which says that you cannot do any major changes 6 months before an election. So I'm saying that if these two are removed, and then that clause is removed, then the fears that we have, that we don't have time for amending Section 88, you understand? So we would have, even in September, we can register the diaspora and then we move on. Because this would have been, once this act comes, it says it's going to delete that one. So it means if it deletes, all the laws there will be null and void. You understand? So we'll move on. So we'll have a pathway, so we will not have any clause that will tell us 6 months before you cannot do. You understand? It will be open-ended. So it's just a question of the political players coming together for the interest of the country, and then we move on. That's what I mean. I think, yeah.
Yes, but the issue of Section 39(1) would not be a challenge. Because
no, it has to. It still has to be. Yes. Yeah, but it has. But you know, 39 is not a problem. It's the 88 that is a problem. It's 88 which says that we have 53 constituencies. That is a problem. You understand? Yes. So, but I'm trying to tell you. Then there will not be any law to tell you you cannot do this thing. So we can work, because as I said, the election, the register, the proper register may finish. The complete one and the authentic one may be around end of September, October. So if you work very hard, like in September, even if you repeal all the laws, because we are still in what? We are still in April. So if you work and then we make sure that these laws are done, you know, by August, in September, maybe we can register the diaspora. That's what I'm trying to say. I hope it's clear.
You confirm to this committee whether you wanted to remove any decision making from the inter-party committee from this 2020 election bill coming.
And you have some strict deadlines in which you have to do A, B, and C. And sometimes some of those issues need urgent decision making. And of course, we know political parties, even in the House, we do watch you on TV. Sometimes you never agree on some issues. So talk less on elections, on a key decision. So this is why it is being proposed that the IEC must not consult the inter-party, or even worse, the CSOs in making its decisions. So this is the point that we're making. Maybe the Vice can clarify more.
Now let me just clarify. What we are seeing, you know what road that is, if you look at your bill, registration of Gambians living abroad, section 14.2, this bill you have, 14.2. It says, the Commission shall, in consultation with the inter-party committee and cabinet, inter-party and cabinet. So that's where we flat. We said, instead of that, why not we consult the National Assembly? I think he didn't explain it properly. So that's the problem. So it says inter-party and cabinet. So we prefer to consult the National Assembly. That's section, that's 14.2. 14.2. Maybe he didn't explain it properly. But that's our position. Instead of inter-party and cabinet, which we think will be a bit cumbersome, we deal directly with the National Assembly. Because when it comes to nationality and all those things, you deal with those things and then amending the law. So it will be easier for us to deal with you than to deal with both the National Assembly and cabinet. It's here. It's in the. It's here. So maybe he didn't. You know, he jumped this section. So that's that. We have nothing against inter-party. Until let it be clear, please, because we know you are all from parties. Yeah, but this is when you come here, it's for Gambia. So that is why we say we deal with you instead of dealing with these two. That's our position. I hope it is clear. Not so, bro. Not so.
Honorable Madam, does that clear your doubt? Okay. I have Brikamanot. Next on the list. Honorable member for Brikamanot.
The representative of the AG chambers said they have no idea regarding that, and then they would like that question to be posed to IEC if they appear today. And that is to say, I compared the bill with that of the current act, section 13 of the act, which is about qualification for registration as voters, 13.2 D, section 12 D of the act, qualification for registration, which is about a document certified by 5 elders that the applicant is a citizen of the Gambia, has been omitted or has been removed for the bill. There is nothing of that in the bill, and I would like the IEC to clarify the reasons advanced or the justification for the removal of that particular clause from the Act.
Why this was deleted is the confusion it creates. Because when you say 5 elders, we have a group of 5 elders here, a group of 5 elders there. Because even the interparty, when we had this consultation with them, they all agreed that the registration should be nullified. And when we had our Congress, at the third time, they just came to say, no, it must be there. Because they realized that those with ID cards in the Gambia are less than 20%. And to get a birth certificate, some of them don't have it. Not talking about our passport. That's why we deleted those, because those 5 elders, who's going to select them? That's the problem. And you may have 2 or 3 teams doing the same thing. This is why it was deleted.
Yeah, let me just. We didn't just delete it. Those were in the National Assembly. I can remember 2015. It was part of those sections that were amended. 2015. I can remember in 2015 it was amended. So that's why that's why we have problems. So that's why we say the law, there has to be a connection. You read one, it tells you the schedule. You have to take care of because it was removed from the text. But the problem is it was not removed from the schedule. So that's the problem we have. So that's why in 2016, if you look at the notice, it was not there. So that's why this year is not there. So you have the 2009. So if you have the 2009, Elections Act is 2009. But we also have to make sure that we have all the amendments to the act, so that we don't just read it, because it's a parent act, but you have the amendments. So that at least you read them in tandem. It's 2005. In fact, I forgot. If you don't have a copy, we can make it available. It's here, yes. So we have. So it's amended. It was amended in 2015. So it's no longer in the act. So we just So if you look, we have we have almost. Chairman has already signed the notice. I think it's there. So it will be indicated together with the team movements and of course all our names. The principal registration officers, because it's according to the Elections Act, Section 16, all of those things should be indicated. Yeah. Okay? Anyone else?
Which are not raised by anybody, except during our period. One is that I just want to observe that any alteration that you are going to bring will be considered by us, and it will be part of our recommendation to the plenary. It cannot come as a new bill, because the bill is already introduced to us. Okay. Apart from that clarification, I want to also say that I have seen that the new bill has incorporated coalition built in there. But for me, it has not gone far, because if people come together or parties come together to form a coalition, they will have to have some certain guarantees as to how that government is going to be run. But if you form coalitions and then you win, then they will say, all the problems it has created for us. And the bill is meant to reduce those problems. So we need to really stipulate exactly how these coalition parties can come together, and if they come together, how their parties are going to run. So that there is some guarantee that people are not going to waste their time into creating coalitions, and then that is one. Two, Mr. Khan and I know that we almost have classes at Bassi regarding a collation of results. When it comes to collation of results, what is the criteria? What are the procedures when it comes to collation of results? Collation of results, my understanding is that you go from polling station to polling station, add everything together, everybody is satisfied, and then you announce that, and then everybody knows that this is the result. But if you just tell me in Wuli this is your result, in that place this is the result, then I believe that is not collation, that's announcement. And we are not going to waste our time spending the whole night for you to tell us what we got in this, when we already got it from our polling agents. So my suggestion is that collation is not captured in the new bill. And we need to have a provision for collation. how do we go about collecting the results? I think that'll be important. Those are the two I want to mention. Thank you.
This is not existing in the current act. So the bill is bringing it up. I think good enough. Then also with regards to the collation center, how does it operate like? I think wasn't also captured. I think these are very good recommendations. Thank you, Honorable.
Thank you very much. Let's have nominated member JJ.
Thank you. Thank you very much, Honorable Chair. I would just like to take you back a bit on the issue, on the diaspora issue and registration. You mentioned rightly that Section 39 does not need to be amended. This is also my view, because it is important that every person is registered under a constituency to know who is who and for the purposes of National Assembly elections. But Section 88 is the problem, which states the number of constituencies we have. Initially, I had this proposal that if amendments are going to be an issue, why can't we register the diaspora? I posed this question yesterday to the ministry, who said, by the way, he was the one who noticed this issue and called your attention to it, not the other way around. I need you to clarify that. So he said, I asked him whether if I am from Dipakunda living in the diaspora, they can still register me on the Dipakunda mark diaspora. He said that is for you to decide, not him, whether the modalities of that is going to be possible. But just opening this, I found something very interesting that might bring the end to this entire discussion. I'll refer you to Section 50, the National Assembly constituencies. It's delimitation of constituencies. It says 51, an act of the National Assembly shall establish a boundaries commission which shall be responsible for demarcating constituencies boundaries for the purpose of elections to the National Assembly. It says 2, the National Assembly shall prescribe by an act the criteria for demarcation of the constituency boundaries. And it says 3, until, please emphasis added, until the National Assembly establishes a boundaries commission under subsection 1, the constituencies as prescribed in part 2 of the first schedule to the Election Act 1996 and any additional constituencies required for the purposes of section 88(1)A demarcated by the Independent Electoral Commission in consultation with the appropriate ministry shall be deemed, emphasis added, to be constituencies for the purpose of returning members to the National Assembly under that section. This is very important. It ends the debate whether section 88(1) has to be amended. This is saying you don't need to amend section 88(1) all the time. It says if the IEC, who is now giving the responsible for demarcation, demarcates now, published in the Gazette, the diaspora constituencies, those constituencies are automatically deemed to be part of section 88(1). I think the debate has ended. Now falls on the shoulders of the IEC. You are responsible to demarcate, and we want to know exactly what their plans are. I missed it, but I saw in the notes that you're planning to demarcate the diaspora into 4. So the process of this is what is important immediately and right now, that the demarcation is done and it's gazetted and the world knows these are the diaspora constituencies, so their registration can go alongside our registration. And also because the bill is now not an act, you can provide rules and guidelines. Normally, you mentioned the issue of the fact that the inter-party and cabinet might be an issue, and you wanted to be in the National Assembly. Now, Section 80 of the Standing Orders also requires that any rules, these are subsidiary legislation, be subjected to National Assembly. So you have to come here for us to decide on the rules that will be accepted. Yes, no, Section 100 of the Constitution, Section 80. Now, National Assembly is subjecting all subsidiary legislation to the approval of the Assembly. So I just wanted to bring you the notice and also advise that immediately the decision on the boundaries be made and gazetting be done, and it will be, in my interpretation, deemed to be law immediately. Thank you.
the person in Dipakunda or something. I'm just giving an example. But what you're saying, Section 50, until with Section 50, I know that. We'll work on that and see. That's why I said, like, coming to whether we are the ones who spotted 88 or 39 or what, my position is this is no time for, it's time for work. We all, no time for apportioning blame or things like that. We are looking for a solution. We move together and find this solution. Yes, I think that's my position. And anywhere I go, that is what I see. It's good that you flag and then you are what? So what we do is we look for a right interpretation of that section. If it's okay, we move on. Then we are done with Section 88. Okay. So I think that's what I'm going to say. We look for like the constitutional lawyers, to help interpret that section for us. Once it is deemed to be fine, we don't have problem with Section 88. Then I think our prayers are answered.
Common sense
yes.
cannot require for the Constitution to be amended any time you need to demarcate. That is hard work. So I think that is why this is placed there. You can do further research and see. So can I ask another question? Different or is
no? Well, you have your chance. Yes.
One can only ask one question.
No, because the
okay.
list is too long. The list is too long.
We are waiting here.
The list is too long. Yes, can you hand over the mic to the Honorable Speaker?
My name is only list there.
Yes, thank you very much.
You're fighting with the speaker.
Another meeting there. I am happy to hear that you intend to move forward. And the fact that you're going to look for constitutional law experts, I can assure you that you have them here galore. And I don't have to name names, but the issue is for it to be done expeditiously. If you can contact them, the list is long. You can have divergent views and come up with the best. That's all I want to say. Thank you. No, we can do that in private.
Be observing not to actually make comments, but it will be very prudent to actually make clarity on the point that the honorable member raised concerning about the Constitution. So if you look at Section 88, it only talks about the composition of the National Assembly members. So the National Assembly members, right? That's why I use the word comprise. And that those members should come from a constituency. Now the question is, how do we define a constituency? It's a defined territorial area, that people actually elect, they are entitled to elect a person to represent them in the National Assembly. Now, if you want to create a diaspora constituency, meaning they need a representative to represent them in the National Assembly. So if you go by Section 50, it's only trying to tell you that those members that are elected from the constituency, the IEC should determine the limitation of those constituencies within the country. It's not actually telling you an increasement of the constituency, it's giving you that the power to the IEC to actually make it, the limitation of those constituencies, where the members should come from in the election. So if the National Assembly, if there is no provision of that, then the schedule will guide you for now. The IEC can come at any time and cancel what is in the schedule and come up with their own delimitation and say from this area to this will be the consequency this, and then from this area will be the consequency that. Right, so but anytime you want to create a new constituency, meaning automatically you have to amend 88 to increase the membership too. That's my position.
So what I'm saying is, it's now up to the IEC to consult further. The Honorable Speaker have given them the information that they can get as many constitutional lawyers as possible, consult as widely as possible and take a position. And again, the Vice Chair of the Commission have made it categorically clear that it's not about blaming who did what, but it's about trying to get solutions and then we move ahead. So if this issue is bringing a lot of debate, I want to propose in consultation with the co-chair that we allow IEC, because that's not the end of it, they will appear and reappear. And in fact, I said it earlier on that they will accompany us throughout the whole process. So IEC will at any given time be in our midst. For the purpose of time, can I now invite the Honorable Member for Ilyasa to ask his question?
13. Yes. Bill. Election bill. Qualification. Yes. For example, yes. What I am proposing that I want the IEC to maintain these 5 elders. If you want to discourage fraud in our election or in even the registration, and we should maintain these 5 elders. Otherwise, the non-governments will, register, and that one's going to bring chaos in the election. That's my question. Thank you.
Thank you very much. I think my cases are somehow scaled down because 3 of the issues I had were asked by some of the members. I just want to observe that if you look at the bill, in fact, the IEC man have also explained that is the requirement of residency. And if you look at the bill, it's not defined there. You don't define resident. What is resident? The bill is just saying resident. The Constitution is saying ordinary resident. These are 2 things, and I just want to flag that. My question was going to to section 3, sub 3 in the bill. I looked at it, but it does not indicate any application date. So you said when this bill come into force, there is no transitional provision. When it is passed, when will it become to effect? That is not indicated. So I think there should be, once it is repealing a existing law, it should have some transitional provisions to tell people exactly this will commence on this specific date prior to this and this and this. I think that is a question I want to know whether it's not important. So basically, the other issues are addressed by other colleagues. I don't know whether you heard me. Yes.
It's not talking about coming into force.
Yes. Can I come? Yes. What I want to say there, you mentioned in your deliberation that when we go ahead with registration and leaving this clause there, it means that when this law comes into force, it will invalidate the registration. I think that's what he was explaining.
He said as from the coming into force of this act.
Yes.
So if it comes into it's a bill, but if you pass it, it becomes an act.
Yes.
So you feel like we started.
Yes. So that is it. It should have at least that's what you. But amending laws is not easy. Exactly. So amending laws is not easy because it takes a lot of process and procedures. So if you bring in something that might be affected by the changes in the process of the law, you cater for it so that it will not affect that work, because registration is not a simple work.
Okay, it's good that they have heard you clearly. The Vice Chair is saying he's understanding the point you are trying to put across. That being said, can we now have the Honourable Member for Fonyi Bereket?
Thank you very much, Honourable Co-Chair. Mine, I would like to seek for further clarifications. If I could fully remember, it was the Vice Chair who have made mention of the insertion of a new clause to take care of the extension of life of the registration card. Was it the Chair? No, it's not necessary. It was also mentioned. Now, what I would like to know that how or who will be responsible for that, if you didn't explain that, and how and when.
I think that one also. I think maybe the way he said, because in the current act, I don't think that it's saying there is minimum. But in this bill, it's specific. It's saying 10 years. I think that's what you wanted to explain. So I think in this current bill, it's specific. Like the current one, it's saying minimum 10. But this one is specific. It's 10. It's there. It's put in there 10 years. But 10 years. But there is also another section which I cannot remember offhand, which says that in case we after 10 years we cannot do a registration, you know, the existing cards, even though they are 10 years old, will still be used. I think that is what he wanted to explain. So that's it. So that's it.
Yes.
I think you can. I think.
Maybe if I may just further clarify that the actual lifespan is 10 years, but in case there is a problem, for example, just as we are facing now, the IEC proposed the registration to happen in January. It didn't, for some technical reasons. Then again, if it couldn't hold again in May, June, is it May, June, July, then that to solve that problem, how do we go about that? That is to create a provision that will allow for the register to be valid more than 10 years. Yeah. So this to prevent a catch-22 situation. Yes.
Honorable, your concerns are enough. All right, let's have the Deputy Speaker now.
Thank you, Co-Chair. Election Bill 2019, Section 43, Payment of Deposits. I want to find out from IEC, because it appears that there was an increase. What is the yardstick used for that increase? The President, the National Assembly, and mayors.
Negotiations began in 2019. Everybody was consulted, and even and then up to the stage of the validation. And this, you know, is a product of what all of us agreed, all the stakeholders agreed. In fact, what we had was, we had some, because it was a heated debate when we came, because people were saying political parties, we had more political parties, and then we had more candidates and the like. How do we sanitize and see? I think if sorry for my the word I used, but that was in fact what was in fact agreed during the validation was political parties, presidential candidates coming from political parties should pay 500,000, and those from non-independent should have even paid more. In fact, that was what was agreed in the validation. So it is not just IEC, but it's only because the last validation was held on 23rd to 24th of September at the ICC. I'm sure some of us, you know, here were there. No, Kairawa was the one that was organized by the Ministry of Justice with the aid of IDEA, not so. Yeah, but we had what? After that validation, there was a general validation. That's the product of this. So that's why all of us, in fact, it was the former SG who chaired that. So we're all there, and all these things were agreed. So for us, it means that we initiated the reform. But at the end of the day, the agreement is all the stakeholders. So I think it's a question, not for IEC, but for everybody. But there was a reason for these things. It was just saying that, I mean, because I know in 2017, there was an amendment to take these things back. I can remember. To take them back to 10,000, 5,000, and then 2005, and 1,250. But during the consultations, it was agreed that we put them back. We put them back. Yes.
And also, one have to accept that the presidential candidate, just the ballot box, will cost us $2 million per candidate, $2 million per candidate.
No, 2,000.
You have almost how many polling stations?
1,400.
Presently, and it can go up. 1,400, yeah, it will cost 2 million because to make the ballot drum will cost 1,500 just to produce it. And on top of that, you have to get paint it, the color of the candidate, the symbol, and the transportation. It's a logistic nightmare. So that's why this is I have to consider.
Well, what I want to say here is I think what the Vice Chair made mention of as far as these new figures are concerned, it did not come out of the blue. There was a validation, and maybe not, if not all of us here, but few of us must have attended that validation. So the figures, the new figures are informed by the stakeholders to the validation. Whether the figures will remain as they are or not, that is still up to the joint committee, because this is why the bill is entrusted in our hands. So we may conclude to say this is the opinion of the people. We're going back to consult the same people to get their opinion, because now whatever we finalize on, once agreed upon and passed, it becomes law. So let's take note that these are gray areas that we may revisit. On my list again, I now have the honorable member for Jana Center.
Yes. Yes, clause 12 of the bill.
Yes.
12.2. The Commission shall cause each register to be divided into such parts as it may determine, and shall include the following details of each voter. Then it continues naming up to G. But if you look at all those things that are supposed to be included in the voter card, I did not see the polling station from the holder of the voter's card is supposed to go and vote. And I understand in the previous voter card, the voter holding the card can know which polling station is he supposed to vote. So is it that this voter card coming will not have such? That's my question.
And also, an addition to that is the photo.
Exactly, okay, you see.
But again, when you register, you are told you vote where you register. You vote where you register.